I move that the question be now put.
Julianne Genter.
Thank you, Mr. Chair. Tēnā koe, tēnā koutou e te whare. Mr. Chair, the government, the minister and government members have consistently made claims this evening that this legislation is not eroding the rights of workers or the important role that collective bargaining plays in our economy. And yet, if we look at the specific clauses in Part 1 of this bill, it is very, very clear that that is exactly what this legislation does. So, clauses 7 to 10 turn the original intent of good faith collective bargaining completely on its head. It removes the requirement for collective bargaining to be concluded as an example of good faith, and it extends the amount of time during which bargaining cannot be done. Clause 9, duty to conclude bargaining. So these clauses allow parties to apply to the authority if things get difficult. It means that workers will not be able to strike for a period for at least 60 days before bargaining can be initiated again, and it places workers in a very weak bargaining position. Clause 11 gives employers the ability to opt out of multi-employer collectives, which my colleague Jan Logie very eloquently explained is going to result in all sorts of difficulties for workplaces where there simply isn't the ability for employees and management to find collective solutions to some of the problems that they're facing. Clause 15 to 18 removes the right of new employees who have not yet joined a union to be offered the collective agreement if there is one already in place on site. Clause 28 to 42, we've heard a bit about Clause 30. These clauses amend Part 6A of the original bill, which gives workers in some occupations where contracting companies regularly turn over a measure of job security by ensuring that they can be employed by the new contractor. So what this does is it means that companies with fewer than 19 employees simply will not have the same guarantees that other employees have in larger companies. And look, the sum total of Part 1 of this bill is to erode collective bargaining, to erode the rights of workers. And I would like to ask those in this chamber, particularly members on the opposite side of the House, and those watching at home to think to themselves, when have they been the most effective, motivated, and productive? It's common sense that people work most effectively when they are not stressed, when they are not overworked, when they are paid a decent wage and don't have to stress about making ends meet. The government claims that these changes are about making our economy more productive, but in fact, they are simply benefiting a small number of people, and they are not benefiting the economy as a whole. Now, I know there are a lot of great employers out there who realize that people work more productively when they are well looked after. But the reality of human nature is that not everyone will. And in the absence of collective bargaining and good employment law, it is a race to the bottom. It actually disadvantages good employers to not have law that sets a minimum standard. This is what history has shown us, Mr. Chair. Before the collective action of workers who fought for the protection on wages and working conditions, people worked in horrific conditions, and that was to the benefit of a small number of industrialists who had mainly inherited their businesses and wealth, but it wasn't to the benefit of the overall economy. It was organized workers who fought for better wages and conditions, not the invisible hand that delivered that. And I just have to quote Adam Smith here, that great father of neoclassical economics. He observed this. He wrote that the interest of manufacturers and merchants in any particular trade or manufacturer is always in some respect different from and even opposite to the interest of the public. And I think this is the common theme of this national government. In their policy and legislation we see implemented, they are acting in the interests of some employers, of some trades and industries, and claiming that this will be better for the economy as a whole, when in fact it is the opposite. It is the very opposite. And we know, if we look at the evidence from overseas, that the countries that are richer and more productive than New Zealand actually have more collective bargaining, more unionized workforces, not less. They have better employment conditions. They have more time off. and they have guarantees for workers. Liberalizing our economy. We can't liberalize our economy anymore. I'm sure the member, we already have.
Jamie Lee Ross.
I move that the question be now put.
I want to warn the House that I'm getting very close to taking the closure. What I will be looking for now is not only relevance but novelty. We've got to have some new arguments and new material. Sue Moroney.
Mr. Chair, opportunity to make another contribution on this bill. I want to make an additional point on clause 56 of part 1, because my colleague Ian Lees-Galloway quite rightly